Good afternoon all. Thank you for joining us for what promises to be a very interesting presentation on the breach of personal data and the importance of cybersecurity. We have two fantastic presenters lined up, Nadine Mather from Bowman and Zamani Ngidi from Aon Cyber Solutions. By way of some housekeeping, please post any questions you may have during both presentations. We have set aside time after the presentations have been completed for questions and answers. Turning now to our first presenter. Nadine Mather is a senior associate at Bowman, specializing in employment law and data protection. Nadine specializes in employment-related issues, including corporate restructuring, restraints of trade, employee benefits and retrenchments. She also advises on data protection, for example, managing employees' personal information, conducting background checks, transferring personal information to companies abroad, and processing health information for COVID-19 purposes. Nadine has a keen interest in data protection laws. She has participated in various panel discussions with the Information Regulator and regularly presents on the provisions of the Protection of Personal Information Act. I'm going to hand over to Nadine.
Thank you very much, Andre, for that introduction, and thank you to our participants who have joined this webinar. As mentioned by Andre, for purposes of today's webinar, I will be providing you with a very brief overview on the conditions for lawful processing of personal information, with a particular focus on how the Protection of Personal Information Act, commonly referred to as POPIA, seeks to regulate data breaches. Now, there is an increasing focus on what businesses are able to do with data containing personal information. This is not surprising, considering the increase in data breaches taking place globally. Now, some of South Africa's most notable data breaches that have taken place in the past few years include Ster-Kinekor, who was responsible for up to 6 million customers falling victim to a data leak as a result of a flaw in its booking website. Whilst migrating their website, ViewFinds leaked over 900,000 customer details to a public available website. Of course, Facebook came under global scrutiny when it suffered a data breach involving the personal information of 900,000 South Africans being leaked as part of the Cambridge Analytica saga. And last year, in headline-grabbing news, we saw Experian reporting South Africa's largest data breach, in which it exposed the personal information of up to 24 million South Africans and 800,000 businesses to an individual impersonating a customer. So like other countries, South Africa remains vulnerable to the threat posed by data breaches. And in fact, South Africa has been found to have the highest probability of suffering a data breach. Now, of course, the situation has only been exacerbated with the COVID-19 pandemic, and this has increased the volume of data breaches, with many organizations being required to implement remote working, which has resulted in a significant increase in cyber attacks and impersonation fraud. Now, prior to the implementation of POPIA, the Information Regulator was already proactively engaging with certain businesses in relation to data breaches, including Facebook, and stated that these major data breaches underscore the importance of the need for a fully functional information regulator, which will be able to enforce the law to its full extent. So with POPIA now in effect, organizations are duty-bound to disclose data breaches, and we can expect to hear more about data breaches and also witnesses the consequences that an organization may suffer as a result of a data breach. So if we move to the next slide on POPIA. Now, the majority of the substantive provisions of POPIA came into force on the 1st of July last year. Organizations were, however, afforded a 12-month grace period to ensure compliance with POPIA. And this week, the Information Regulator confirmed that this grace period will not be extended. So as of today, you have 99 days until the 1st of July, in which organizations must ensure compliance with POPIA. Now, POPIA regulates the processing of personal information by both private and public bodies. And POPIA will apply to the processing of personal information entered into a record by or for a responsible party situated in South Africa or not situated in South Africa, but using automated or non-automated means that are situated in South Africa. So let's break down some of these terms briefly. For purposes of POPIA, the term process is widely defined, and it includes any operation or activity concerning personal information, including the collection, transferring, transmission, and use of personal information. Now, personal information is in turn information that relates to an identifiable living natural person and, where applicable, an existing juristic person. Now, interestingly, the General Data Protection Regulation in Europe, which is commonly referred to as the GDPR, does not extend to the personal information of juristic persons. It only applies to natural persons. So if there are any multi-jurisdictional organizations out there that are currently complying with the GDPR, this does not mean that they are necessarily in compliance with POPIA. Now, POPIA also identifies a special category of personal information, namely special personal information, which includes information relating to an individual's race, their health, religious beliefs, or their biometric information. And it provides for additional protections to this special type of information. Now, if we move on to the concept of a record, again, a record is widely defined in POPIA, and it includes any sort of recorded information, regardless of the medium or form, that is in the possession of or under the control of the responsible party. So this includes any writing on any material, photographs, maps, any recording on any computer or any other device. And last but not least, the concept of a responsible party. Now, a responsible party is commonly referred to as a data controller in other jurisdictions, but it refers to the entity that basically determines the purpose and the means for which the personal information will be processed. So where an organization is processing personal information that falls within the ambit of POPIA, it will be required to comply with the provisions of POPIA, most importantly, the conditions for lawful processing. So moving now on to the conditions for lawful processing. POPIA is based on 8 conditions for lawful processing. And now the conditions are not applicable to the extent that you are processing personal information that falls outside of the ambit of POPIA, or where the information regulator has granted an exemption. Now, the conditions, of course, do not stand in isolation and often interact and overlap with one another, so they should be viewed holistically when seeking to comply with the conditions. Briefly, the conditions include as follows. So the first condition is that of accountability. And this provides that the responsible party, as mentioned earlier, must ensure compliance with the conditions for lawful processing. This means that although you as a responsible party may appoint a third party to process information on your behalf, such as a payroll provider, you will still ultimately be held liable as the responsible party to ensure compliance with these conditions. Now, moving on to the second condition, which is that of a processing limitation. This condition entails that personal information must be processed in a lawful manner that does not unnecessarily infringe on the privacy of a data subject. This means that when you're processing personal information, you must process it in a way that is adequate, that is relevant, and that is not excessive in the circumstances, particularly having regard to the purpose for which you are processing the information. Now, there is a widely held misconception that you can only process a data subject's personal information with their consent, and this is simply not so. POPIA provides for a number of other grounds on which personal information may be processed, in addition to that of consent. These grounds include where the processing is necessary for the conclusion or performance of a contract to which the data subject is a party, such as an employment agreement, where the processing is necessary to comply with an obligation imposed by law. For example, an employer who is a designated employer under the Employment Equity Act has to submit employment equity reports on an annual basis. This would be regarding as processing information to comply with an obligation imposed by law. Or famous catch-all ground, which is where the processing is necessary to pursue the legitimate interests of the responsible party or of a third party to whom the information is supplied. So there are various grounds on which you can process personal information, and it's just important to bear in mind that the grounds on which you can process special personal information, as I mentioned briefly earlier, slightly differ to the grounds on which you can process personal information. So if you are processing special personal information or intend to process special personal information, due regard should be had to the applicable provisions of POPIA in this regard. Now, the third condition is that of a purpose limitation. And this provides that the personal information must be collected and subsequently processed for a specific, explicitly defined and lawful purpose, which is related to an activity of the responsible party. As part of this purpose specification, POPIA also regulates the retention of personal information, and it provides that you may only retain personal information for as long as it is necessary to achieve the purpose for which you collected that information. Thereafter, you have to destroy it or delete it or destruct it or provide it back to the data subject. Now, of course, there are certain exceptions to this rule. This may be, for example, where a retention period is prescribed by law. We have the Basic Conditions of Employment Act that states that certain employment records must be retained for a period of 3 years at least. And now that is a statutory retention period that you will need to comply with. Coming to the next condition, which is that of a further processing limitation. Now, this condition provides that the further processing of personal information must be compatible with the initial purpose for which it was collected. So you cannot go and collect someone's personal information when you are selling them shoes at a store and suddenly use their personal information for credit record purposes. It has to be compatible with the initial purpose for which you collected the information. And there's a number of factors that a responsible party must take into account to assess whether the purpose would be compatible. And this includes having regard to the nature of the information, the manner in which the information was collected, and of course the consequences of the intended further processing. Now, the fifth condition is a lovely short and sweet condition, and that is of information quality. And this requires a responsible party to take reasonable practical steps to ensure that the personal information it collects and processes is complete, it's accurate, it is up to date, and it is not misleading. So this will require responsible parties going forward to continually check with their data subjects, whether it's their employees or their customers, that the information they have in relation to those data subjects and stored is up to date and accurate. Now, the next condition is that of openness. Now, prior to POPIA, South Africans were often not aware of when or how their personal information was processed. And we have all experienced receiving a call from an insurance provider that we have never heard of, but who has heard of us and has our personal information. Now, this condition actually seeks to regulate that scenario and provides now that you are required as a responsible party to make a data subject aware of certain information before you commence processing their personal information. So you must take steps to inform the data subject of a number of things, which can include the type of personal information you are collecting, the purpose for which the information is collected, whether the supply of the information is voluntary or mandatory, what are the consequences of not providing that information, and any other further relevant information. This can include whether you are transferring the personal information across borders, and what rights data subjects have to the personal information. Now, the seventh condition is that of security safeguards, and this speaks directly to the issue of cybersecurity and data breaches, which is our topic for today. So we will get to this condition in more detail shortly. And last but not least, the eighth condition is that of data subject participation. And this condition ultimately provides data subjects with a number of rights. These rights include the right to request a responsible party to confirm whether they hold personal information of them, to request a copy of the record of personal information or description of the personal information from the responsible party, and also to request details in relation to the third parties who have accessed the information or who could have accessed it in the past. Now, of course, the responsible party may refuse the request, but they may only do so on the grounds set out in your Promotion of Access to Information Act. Some further rights data subjects have is they may request a responsible party to delete or correct personal information it has in circumstances where it may be inadequate, may be excessive, or it may be irrelevant. They may also request you to delete or destruct the information if you are no longer lawfully allowed to retain that information. And again here, a responsible party does not necessarily have to comply with the request, but in the event that they don't comply, for example, they don't agree with amending the information, they must actually physically attach that request to the information to show a request has been made, but that they did not choose to comply with that request. So that was a bit of a mouthful, but those are ultimately the conditions for lawful processing that all 8 need to be complied with whenever you are processing personal information. Now, moving on specifically to the issue of security safeguards. Now, the 7th condition, as mentioned, is security safeguards, and this condition is twofold. First, it requires security measures to be put in place, and second, it regulates the issue of data breaches. So when it comes to security measures, a responsible party is required to secure the integrity of personal information in its possession by taking appropriate, reasonable, technical and organizational measures to prevent the loss of or damage to or even unauthorized access to the personal information. Now, this entails basically taking steps to ensure that you identify the reasonable foreseeable risks to personal information in your possession. Once you've identified those risks, to establish and maintain appropriate safeguards against those risks, to verify that the safeguards are effectively implemented, and of course to ensure that the safeguards are continually reviewed and updated where necessary. Now, the details of the security measures will need to be included in your compliance framework as a responsible party, which must be prepared by your information officer. Unfortunately, POPIA does not provide detailed guidance as to what measures would be appropriate and reasonable in the circumstances. POPIA does, however, require a responsible party to have regard to general accepted information security practices that may be applicable to it generally or may be imposed on it as a result of the industry it falls in and subject to industry rules and regulations. So these security practices may include antiviral software, setting up a firewall, or having strong passwords. And given the increase in remote working, it's more important now than ever to really ensure that your security safeguards are up to date. This may include limiting access to use open Wi-Fi's and also ensuring that all laptops are encrypted to ensure that no one can access the information. In addition, as part of this requirement, if you as a responsible party intend to appoint a third party, which is referred to as an operator under POPIA, to process personal information on your behalf, you are required to enter into a written agreement with that operator, which requires the operator to implement and maintain appropriate security safeguards to protect the integrity and confidentiality of the personal information it processes. So you may have to go back and just review some of your agreements if you have any in place with a payroll provider, with medical aid, with a retirement fund, to just ensure that adequate security measures are being put in place. Now, moving on to the second part of your issue of security safeguards. Now, the second part is that of data breaches. Now, prior to POPIA, organizations did not have a duty to report or disclose a data breach. And the only time we learned about data breaches is when they made headline news or when a publicly listed company actually suffered one. However, the position has now changed. And in August last year, interestingly, 1 month after POPIA had come into force, the information regulator confirmed in a media statement that it already had received or had reported 25 data breaches, 19 of which were self-reported by the responsible party. So there is an increase in data breaches in South Africa, which really makes these provisions relevant. So for purposes of POPIA, what is a data breach? So a data breach occurs where there are reasonable grounds to believe that the personal information of a data subject has been accessed or acquired by any unauthorized person. Now, a data breach under POPIA is accordingly widely defined and can encompass a number of potential security compromises. A data breach may, for example, occur as a result of an employee clicking a fraudulent link that is received in an email and the personal information stored hasn't been sufficiently protected. On the contrary, we've seen scenarios where employees' laptops have been stolen. However, as a result of the laptop being encrypted, there aren't actual reasonable grounds to believe that someone would be able to access the information, and that may not constitute a data breach under POPIA. So the ultimate question is thus whether you have reasonable grounds to believe that the personal information can or has been accessed or acquired by any unauthorized person. Now, where a data breach occurs, the responsible party has a duty to notify the information regulator and the data subjects concerned, unless the identity of the data subject cannot be established, as soon as reasonably possible after the discovery of the data breach. And this is, of course, taking into account law enforcement processes or any measures that are reasonably necessary to determine the scope of the data compromise and also to restore the integrity of the information system. Now, the term "as soon as reasonably possible" is, well, fairly vague. For example, Experian discovered their data breach in July last year and reported it to the information regulator in mid-August. Now, the information regulator confirmed that this notification was not made as soon as reasonably possible in terms of the Act, and has since indicated that it would regard 72 hours as a reasonable period. And this is not surprising because this aligns with the approach followed in the GDPR, which also requires organizations in Europe to report within 72 hours a data breach to their data protection authority. Now, the notification of a data breach must be made in writing, and it also must contain sufficient information to allow the data subject to take protective measures against the potential consequences of the data breach. So this includes providing, at a minimum, a description of the possible consequences of the data breach, an outline of the measures that the responsible party has taken or intends to take to mitigate the data breach. It must include a recommendation to the data subjects of what measures the data subject can take to mitigate the possible adverse effects of the data breach. And if known to the responsible party, they are required to disclose the identity of the unauthorized person who has accessed the information. Now, this notification can be provided to a data subject by hand, via email. It can be placed on a prominent position on the company's website, or it can even be published in the news media. Now, interestingly, POPIA provides the information regulator with the power to require a responsible party to publicize a data breach if the information regulator has reasonable grounds to believe that such publicity would protect a data breach. So it is accordingly likely that we'll hear about many more data breaches in the upcoming month as a result of a lot of them potentially having to be publicized on the instructions of the information regulator. So if we move now to some of the consequences for non-compliance. A failure to comply with the provisions of POPIA, in particular the provisions of the data breaches, exposes an organization to financial liability. It can also expose them to criminal liability in certain circumstances. And in terms of POPIA, some of the consequences of non-compliance include the imposition of an administrative fine by the information regulator of up to 10 million rand, imprisonment in certain circumstances, and compensation or damages in the event that a data subject or information regulator institutes a claim against the responsible party, and this can include class actions. So, of course, where a responsible party has put in place appropriate security measures that are reasonable and appropriate with regard to the risks identified, where they have notified the information regulator of the data breach and also notified the data subjects, it is going to be extremely difficult for the information regulator to find any non-compliance with POPIA. However, even in these circumstances, an organization may still suffer significant reputational and financial harm arising from a data breach, and possibly even a disruption in the organization's operations. In fact, in terms of an IBM study that was conducted last year, which looked into the sort of financial impact of data breaches, it was revealed that data breaches cost South African companies 40.2 million rand per breach on average. And this far exceeds the 10 million rand that may be imposed by the information regulator. So in conclusion, the provisions of POPIA relating to data breaches intends to strengthen the hands of the information regulator to fight data breaches in South Africa. However, no organization is immune to a data breach, regardless of the security measures you have put in place. So organizations should try and ensure that they have an appropriate data breach response plan in place, that they have a layered security strategy, that they train and equip their employees to be able to identify risky online behavior. And of course, they should consider appropriate cyber security insurance, which Zamani will explore in further detail shortly.
Thank you very much for that, Nadine. It's now my pleasure to introduce Zamani. Zamani is a client manager for Aon Cyber Solutions based in South Africa. He is responsible for delivering cyber quantification and program design to commercial clients operating within Africa. He obtained his qualification in risk management from UNISA, is a qualified ISO, IEC information security lead auditor, and is an associate member of the Institute of Risk Management South Africa. He's currently completing his master's degree with Salford Business School. Thank you very much, Zamani.
Andre, highly appreciated. So firstly, would like to say thank you so much to SASLAW for giving me the opportunity to speak and give you some insight around insurance and how it relates to the new legislation, which is POPIA. Phenomenal summation by Nadine, by the way. And so just as a brief overview in terms of what Aon does from a global perspective, we're a professional services firm that's based out of Chicago and London. We acquired a company in 2016 called Stross Friedberg that specialized in incident response and forensic investigation. So we've been able to come up with some very nuanced solutions around cyber risk management, cybersecurity, and cyber insurance. So with that being said, this is just a general capability slide in terms of what we've done. We've managed 10 of the 30 largest breaches recorded in history. We've placed over 15.2 billion Rand of cyber premium in 2019. We have over 600 dedicated cyber professionals, and we generally tend to approach cyber from an enterprise-wide approach. Now, some of the things in terms of what Nadine said were absolutely fantastic, but needed to be given some context in relation as to how it affects the balance sheet risks that organizations have. So, the evolving cyber risks and the Protection of Personal Information Act, POPI, has created a greater awareness on the financial impact of cyber risk and emphasized the need for organizations to increase their understanding of cyber insurance. Now, from the perspective of obviously being a global organization, we've been able to look into the data and analytics of cyber breaches and the way that cyber insurance and the cyber risk management sector has responded to this over the past decade or so. Again, given the fact that the regulations in other territories are far more developed, GDPR is a perfect example. Also, some of the data privacy legislations in places like California and Australia. So there's been a more coordinated lens in terms of the way that these risks are being calculated from a global context, looking at the liability that comes out of it. And for South African companies, it's sort of this new playing field that they don't necessarily understand and need a little bit more guidance on. So the thinking around where's this drive around the importance of information and how sort of the fourth industrial revolution has really driven the importance of things such as intangible assets. Now, if we look at this slide and we talk about the economic drivers from the left-hand side, we talk about automation and connectivity, right? So part of the things in terms of the way that things were accelerated from a COVID perspective in terms of mobilization, that comes with certain risks that organizations may not be equipped for, and that change in terms of operating model has really given a lens as to how important cyber and managing those data risks actually is. Talk about things such as big data, virtual reality, mobility, which I've touched on, and also social media, and these sort of emerging technologies that are coming into play, such as the distributed ledger, such as blockchain and Bitcoin. And the strategic threats that come out of that are fairly interesting from a disruption perspective, confidentiality risk and supplier risk. So as an example, if you look at confidentiality risks for organizations such as hospital that carry very sensitive information, they're subject to multiple regulations via the payment card industry and also POPI in itself, and also the National Health Act. So these are some of the things that we need to take into considerations when us as an organization help clients to understand their quantification of the risks that they have on their balance sheet, and that's sort of again subsequent to what data they store and the subsequent liability that could occur from those incidents. Cybersecurity risk report, which was published in 2020. Some of the things that really came out there was obviously around technology, the added reliance that we've had on that specific sector and going forward, concerns around the supply chain, right? So Nadine spoke about operators being required to process information and have safeguards in place. These are certain things that organizations have to think about as to how their specific company is impacted by a breach that could occur in one of their supply chains. And thinking about things such as the Internet of Things, business operations, as to companies not being necessarily aware or somewhat oblivious to the fact that this is going on. And I think that the benefit of working in the claims or the insurance industry is that we get to have a look behind the scenes without the requirement for notification as to what's happening in terms of practical quantification of loss, as it relates not only to insurable risks but uninsurable risks. And it's startling to hear this disparity between what is happening in our business environment. And from calls I've had from our colleagues in the US and the UK, the requirement to notify the regulator and also publicize a data breach has actually helped the business environments to again understand those risks as being prevalent and actually start taking some proactive measures as to how they should protect against that. You look at things such as employees. So companies, obviously we protect our customers' information, but also people that they employ also need to be protected. You look at things such as mergers and acquisitions, whereby global M&A has taken place and a breach has actually resulted from the acquired company and not the acquiree, and that's given a huge direction in terms of M&A solutions, cyber solutions specifically, around looking at some due diligence practices from the perspective of, again, that mergers and acquisition space. And then obviously the regulatory aspect comes into place. And you also look at the liability that could arise from the board of directors not actually taking prudent steps to protect their information architecture. So you look at around the cyber risks and some of those considerations. Obviously, we talked about evolving regulation. We talked about some of the supply chain disruption, technological infrastructure, which is again going to change going forward. Obviously, with some of the ways that new organizations are adapting to this new way of working and trying to innovate to again be able to apply those various benefits and economic drivers to their business model. You look at things such as network business interruption. What does a denial of service attack look like, practically speaking, from an organizational perspective? And think about those things from a breach expense perspective. I think that 40 million number that Nadine spoke about is made up from an amalgam of things, right? You talk about getting a team of forensic investigators to come in and remediate the impact from a cybersecurity incident. You talk about things such as acquiring Bitcoin, brokering that transaction. You talk about things such as public relations costs in terms of managing the aesthetics of the way a breach played out and things of that nature. I think Experian, when we look, with a bit of hindsight, the way that was managed was improper, and I think that's sort of the benefit behind having a dedicated PR team to come and do some crisis consulting. And all of those things around thinking about those costs and also some of those intangible costs such as reputational risk, the thinking around, what does it actually cost your brand to be on, the front of the Star, the Sun, or whatever the case may be, and saying that information has been stolen. And then obviously the subsequent liability, right? There's a term that is coming along in insurance, which is called long tail risk. Essentially, we have these claims that are open from a cyber incident, not understanding that obviously there's a civil class action lawsuit that's coming. What does that look like from a quantification perspective? And I think the actuarial modeling doesn't actually understand the way that those limits and the way that liability and the settlements can take place. What will that look like, practically speaking? Now, taking into some of the notes that Nadine spoke about, around these notable data breaches, we did some quantification in terms of looking at the breaches that have been notified. So we look at, the likes of Liberty Holdings over the weekend when they announced that the breach took place, saw about a 5% loss of market capitalization. And thinking about, again, the way that this information is not readily available in South Africa as opposed to the rest of the world. I mean, you can Google a company called Mondelez that suffered a breach from, I think it was either NotPetya or WannaCry, but they lost, and it was declared in their annual report, roughly $300 million as a result of that breach. And this is a breach that again came from one of their vendors from their supply chain. Again, taking into some of the thinking that the risk, at least globally, is a little bit more. There's a little bit more awareness around it, and also a little bit more of thinking as to how they need to fix this issue. And part of that is obviously directing the adequate resources to take care of it. But the back end of the requirement to do so is regulation. You look at some of the system modifications that have happened through Postbank and Landbank that have lost 42 million, and Landbank initially was estimated to lose about 150 million, but post the investigation a lot of that money was recouped. But we need to start thinking about what does that look like from a worst case scenario in terms of the organizations that certain people in South Africa are privy to. And also just a linear timeline as to what those data losses look like from 2016 to 2020. And I think the big key here is that a lot of these breaches will happen, and will only be notified, but POPI makes the impact of a breach far more costly. And I'll sort of touch on that in a second as to practically what that looks like. So we also got to factor in things such as cyber risk as a directors and officers risk, right? So if we look at a security and privacy incident, what will usually happen, we'll use Liberty as an example, even though it practically didn't happen because the regulations aren't, the same way that they were against, a place like the US where they have the SEC. There'll be a breach notification of a privacy incident, stock will drop, and there'll be sort of a breach of fiduciary duty. There'll be a shareholder class action and a derivative suit sort of directing the directors and officers in their individual capacity, and the DNO policy would respond to that. And then, the alternate route, looking at it from sort of a vertical going down, that regulatory compliance, looking at mandatory breach notification, talk about a civil lawsuit, breach response expenses, and how a cyber policy will kick off. And there's sort of this overlap around that regulatory compliance aspect and tying into things like a shareholder class action as to where that liability actually should fall, because the incident that triggers the various policies is different in each sector. So this is just a slide in terms of the way that rationale is played out in the US. A lot of these verdicts are pending. The only two that have been closed is the Facebook settlement for about $100 million, and also Anthem, which was roughly about $115 million from a DNO perspective. And then just to touch on, some of the way that, the ramifications of all of this backdrop of cyber activity has impacted the insurance market, at least in the past year. We've seen what they call a hardened market, whereby the rate to access capital has increased significantly. So we've seen a year-to-year increase of ransomware costs post lockdown, roughly 60 to 70% month on month, and we're starting to see that trend again, partly because of the importance of mobilization, but also understanding that insurers are now starting to limit the coverage that is available in cyber insurance. The capacity in terms of loss limits is also being decreased. A lot of towers in the UK market have been burned quite badly. Talking about loss limits of about 500 million UK sterling, and the pricing obviously for the coverage has increased dramatically. And then also the retentions in terms of the amount of money that is required to be self-insured has increased tremendously. And that's just the thinking around making sure that organizations are putting a little bit more of their own skin in the game in terms of protecting their IT environment and not just offsetting that to the insurance market. And then from obviously the perspective of understanding things such as silent cyber, whereby in other policies there's an aspect that could sort of be triggered by a cyber incident. And what we're seeing from a global perspective, especially from the underwriters and Lloyd, is a coordinated effort to specifically sort of carve out cyber coverage. And again, it's just to make sure that there's no confusion as to where those losses and those liabilities should lie from a wording perspective. Now, we'll talk about an insurability case study, and this will probably be my last slide before I close off. But understanding, what would happen from a ransomware attack of a breach of about 100,000 records. So the event management costs will be covered. You look at the incident response and forensic investigators. The city of Johannesburg ransomware attack cost the municipality roughly about 50 million rand. Obviously, the ransom payments that I spoke of will be covered in that policy. The network business interruption, so during the period that the organization is down, whether it be from a denial of service or regulatory investigation, the policy would also seek to sort of remediate some of those impacts. And then you look at things such as credit monitoring. So affected data subjects may have fraudulent accounts open in their name, and basically credit monitoring would sort of monitor that information isn't taking place. Otherwise, the organization that originated, the breach came from would have consequential liability associated with that. And then also, the notification of data subjects, liability defense costs and possible third-party claims, and also the regulatory investigation. So I think the thinking around what does POPIA do for an organization in terms of changing the way it operates is one thing, but also thinking about the subsequent liability that comes from there. So from that standpoint, I think, there is an insurance and data privacy white paper that I've just authored that is available on our Aon website. Please give it a read. And I think with that being said, Andre, I'll hand it over to you.
Thank you, Zamani. I think I speak for all participants that was a very interesting presentation. We have had a few questions coming through during the course of the presentations. Those questions are for Nadine, so I'm just going to ask a few of them and then we can switch over to her. So Nadine, the first question we have is, does an operator include staff members in payroll, for example, where they process personal data on employees? And then the second question, we can deal with two for now, and then I can ask you the third one later. When can the legitimate interest principle be used?
Thanks, Andre. So I'll briefly deal with the questions. The first one, ordinarily, no, your own employees wouldn't be regarded as an operator. They are working for you. Their duties are as employees under the employer and you being a responsible party. So that would be the responsible party processing the information. An operator comes in where you actually appoint a sort of third party, which could be an entity, it could be a consultant that's not actually, an employee within the company, that helps you with your payroll providers, in which event you will need a written agreement. It could be, if it is just a consultant that comes in, to assist with payroll, a simple, 2-page agreement where you just ensure that they're going to keep that information confidential. There's appropriate confidentiality undertakings, and any security safeguards are also put in place that meet the measures of your security safeguards as a responsible party. And then briefly in relation to the second question of legitimate interest, this catch-all ground that a lot of organisations like to use, it really is quite wide in terms of legitimate interests. If we are looking at an employer, for example, you can process employees' information on the basis of the legitimate interests of the company to ensure that you have an inclusive workplace, that you are, promoting inclusivity and diversity. You can do it on the basis of incentive schemes that aren't necessarily subject to a contract, but sort of within the legitimate interests of both the data subject and the company. You can process information to holding companies for directors for purposes of group management levels in the legitimate interests of the company. Another great example in the sort of legal context is your transactions, your mergers and acquisitions. We do a lot of due diligences where a seller has to, provide information to the purchaser to assess the acquisition, and that would be actually in the legitimate interest of a third party to who the information is supplied. So those are just some examples, but really the list is not limited.
Thank you, Nadine. Those answers were very helpful. So just by way of the last question, how are companies held to account when they receive a cold call from a service provider they've never engaged before and they haven't divulged, and they don't divulge where they got your details from?
Well, I suppose the answer is you put down the phone, but thankfully POPIA also regulates the issue of direct marketing. Which is by unsolicited means, however, so it's talking about emails and also generated calls that we get that left message on our cell phone that's a robot telling us what insurance packages are available. Doesn't obviously include cold calls as you're talking about that, but that would still be regulated in terms of your Consumer Protection Act. They have your that deals with your direct marketing. Ultimately, how you deal with it is you could report the matter. You wouldn't necessarily report it you could report it to the information regulator on the basis that you don't know where they got the information from. You feel that there's been an alleged interference with your personal information. That would be one way to deal with it, and the actual regulations of POPIA contain the appropriate form on which you can file a complaint. Otherwise, you are dealing with the Consumer Protection Act, and hopefully the fact is with the POPIA that many organisations will no longer be able to just sell these huge databases containing all our personal information, which is what happened in the sort of previous era, where you could just buy databases of information and your service providers, insurance companies, estate agents could use that information and cold call people. That practice has actually been prohibited under POPIA. So we hope to receive less of those calls. However, it may take a few complaints to get the information regulator to investigate it.
Thank you very much for that. From SASLAW's side, we would like to extend a massive thank you to Nadine and Zamani for a fantastic presentation. It was very insightful. Thank you both for making your time available. And then just for all the participants, you will see there's a slide up at the moment, save the date. So this year, SASLAW is once again doing a hybrid conference. It's on the 7th and 8th of October 2021, and the physical conference will be taking place in Johannesburg this year. So please do pencil that into your diaries. Thanks again, once again, for all of you who have attended this presentation. We really appreciate it.